Step out of the vehicle, now.
Officer, I provided my license. What is the reason for this stop?
I said step out. Don't argue with me.
I'm not resisting. I'm asking a lawful question.
Hands on the hood. Do it.
I do not consent to any searches.
You don't decide that.
Tuesday, 2:17 p.m. What appears to be a standard traffic stop is actually the beginning of a systemic collapse for the local police department. On the surface, the interaction follows a familiar script. Blue lights flash. A vehicle pulls over. An officer approaches. But the variables in this equation are catastrophic for the state. The driver is Barbara Taylor, a 52-year-old sitting federal judge with 15 years on the bench and a terrifying command of constitutional law. The officer is Marcus Wright, an 8-year veteran with a personnel file full of commendations that mask a predatory operational pattern. Wright sees a luxury sedan driven by a black woman and calculates a target. He assumes he is dealing with a civilian who can be intimidated. He has no idea he has just detained a woman who presides over federal sentencing hearings. This is not a random encounter. It is a collision between the rule of law and the abuse of power. Judge Taylor's conduct prior to the stop is clinically perfect. She is traveling 5 miles under the speed limit. Her registration is current. Her insurance is valid. There is no erratic driving, no broken taillight, no probable cause. Wright initiates the stop anyway. In legal terms, this is a pretextual stop, often legal under Warren v. United States. If a traffic violation exists, but here there is no violation, Wright is fishing. Upon approach, Wright's hand rests on his holster. This is the first aggression. He demands documentation without stating the reason for the detention, a tactical move designed to induce anxiety. Judge Taylor does not panic. She provides her license and registration, then asks the critical question, "What is the reason for this stop?" Wright refuses to answer. He retreats to his cruiser, leaving Judge Taylor detained on the roadside. This is where the legal violations begin to compound. Wright sits in his patrol car for nearly 20 minutes. Under Rodriguez v. United States, the Supreme Court has ruled that police cannot extend a traffic stop longer than necessary to address the alleged infraction unless they have reasonable suspicion of a crime. Wright has neither. He is running her data through every available federal and state database, hunting for leverage, warrants, unpaid fines, anything to justify his harassment. He finds nothing. Her record is cleaner than his own. Frustrated by the lack of criminal history, Wright returns to the vehicle and escalates the kinetic energy of the encounter. He orders Judge Taylor out of the car, while Pennsylvania v's MIMS allows officers to order drivers out of vehicles for safety. Wright's demeanor suggests this is punitive, not protective. Judge Taylor complies, but she executes a defensive maneuver that will later serve as the cornerstone of her civil suit. She activates the voice recorder on her smartphone. From this moment, every rights violation is preserved in high-fidelity audio. Wright orders her hands on the hood. He verbally abuses her. Then, he crosses the constitutional line. He reaches into the vehicle and searches her purse. In the United States, a warrantless search of a vehicle or personal effects requires probable cause or consent. Judge Taylor explicitly states she does not consent. Wright ignores the Fourth Amendment and rifles through her belongings. He finds her federal judicial identification card. In 99% of cases, this is the moment an officer realizes their error, de-escalates, and apologizes. Wright does the opposite. Blinded by confirmation bias and racial prejudice, he examines the legitimate federal ID and concludes it is a forgery. He accuses a sitting federal judge of impersonating a public official, a felony. Judge Taylor remains stoic. She calmly advises him to contact the federal courthouse to verify her identity. Wright rejects the verification. He tells her he doesn't care who she is, effectively sealing his own fate. He handcuffs her, informs her she is under arrest for impersonation and resisting, and places her in the rear of his squad car. The drive to the county jail is the quiet before the storm. Wright believes he has captured a high-level fraudster who disrespects authority. He is confident, arrogant, and operating under the delusion that his badge grants him absolute immunity. In the back seat, Judge Taylor is not just a prisoner. She is illegal computer processing evidence. She is cataloging every procedural error, every civil rights violation, and every minute of false imprisonment. Wright pulls into the intake bay of the county jail, expecting his colleagues to congratulate him on the arrest. He is about to walk a federal judge into a booking room staffed by officers who know exactly what a federal warrant looks like. The doors to the precinct open, and Officer Wright marches his victim inside, completely unaware that he has just initiated the end of his career. The transition from the patrol car to the booking room is where the dynamic of power usually cements itself. For most detainees, this is the nadir, the moment the system swallows them whole. For Officer Marcus Wright, it was the moment his fabrication began to hemorrhage credibility. Inside the county jail, Wright attempted to formalize his narrative. He approached the intake officers, veteran personnel responsible for processing the county's daily influx of arrests, and laid out a litany of charges. He didn't just cite her for a traffic violation, he requested processing for identity theft, fraud, and impersonation of a federal official. He characterized Judge Taylor as a career criminal, utilizing a sophisticated cover identity. But the intake process is bureaucratic, not emotional. And the officers manning the desk spotted the operational disconnect immediately. Judge Taylor did not fit the behavioral profile of a fraudster. Her speech patterns were disciplined. Her posture was not one of submission or belligerence, but of patient, analytical waiting. She provided her information with the precision of someone who dictates court records for a living. While Wright was occupied filling out the arrest report, a document that would later serve as Exhibit A in his federal indictment, an intake officer made a discretionary phone call to the federal courthouse. This was standard operating procedure for high-stakes identity claims, a fail-safe Wright had arrogantly overlooked. The verification took less than 30 minutes. The clerk of the court confirmed that Judge Barbara Taylor was not only a sitting federal judge, but was currently missing a sentencing hearing on her docket. The confirmation didn't just contradict Wright's report, it weaponized the entire department's liability. The shift supervisor, a lieutenant with 25 years of experience, intervened immediately. In law enforcement management, a bad arrest is a headache. Arresting a federal judge on fabricated charges is an existential threat to the agency. The lieutenant pulled Wright aside and offered him a tactical off-ramp. Release the judge immediately, expunge the booking entry, and frame the incident as a misunderstanding. It was a corrupt offer designed to save the department, but it was an offer nonetheless. Wright declined, whether driven by ego, stupidity, or a belief that he could bully his way through reality. He insisted the judge be processed. He doubled down on the fraud accusation. This refusal to pivot was the final nail. The lieutenant, recognizing that Wright was radioactively toxic, bypassed the chain of command and contacted the police chief, the district attorney, and the local FBI field office. Within the hour, the booking area was sterilized of routine activity. The arrival of internal affairs and federal agents signaled a shift in jurisdiction. Judge Taylor was released from custody, not with the usual discharge papers, but with profuse apologies from the department's upper echelon. She was offered counseling and medical attention. She declined both. Instead, she made a single calm demand. She wanted preservation orders on all evidence: the dash cam video, the booking audio, Wright's arrest report. She wasn't acting as a victim, she was acting as a lead prosecutor securing her evidence chain. She walked out of the jail less than 2 hours after entering, leaving behind a department in freefall. The investigation that launched that afternoon was forensic and brutal. Investigators immediately pulled the data to compare Wright's sworn statement against objective reality. The anatomy of his deceit was laid bare in the delta between his report and the recordings. Wright's report claimed Judge Taylor was driving erratically, swerving across lanes, and endangering public safety. The dash cam footage, however, showed a sedan traveling in a straight line, fully compliant with traffic flow, using turn signals for lane changes that never happened. Wright's report claimed the suspect was belligerent, combative, and resisted lawful commands. The audio recording from Taylor's phone, now entered into evidence, captured a woman speaking in a low, controlled register, asking lawful questions about the nature of the stop. There was no screaming, there was no resistance. There was only Wright's escalating aggression against a backdrop of professional silence. The most damning piece of evidence was the search. Wright claimed he had probable cause to search the vehicle due to furtive movements. The video showed Judge Taylor sitting perfectly still, with her hands visible until ordered out. The search of her purse was a warrantless violation of the Fourth Amendment, executed solely to find leverage that didn't exist. By 5 p.m., the district attorney's office had flagged every active case involving Officer Wright for immediate review. The FBI opened a civil rights inquiry under Title 18, Section 242, Deprivation of Rights under Color of Law. Wright had built his career on the assumption that his badge gave him the final word. He believed that in a contest of credibility between a cop and a black driver, the system would default to the officer. But he had failed to account for the digital trail. The dash cam, the body cam, and the smartphone audio didn't just prove him wrong, they proved him to be a liar. And as investigators began to peel back the layers of Wright's personnel file, they realized this wasn't an isolated incident. The discrepancy between Wright's reports and reality wasn't a mistake, it was a methodology. Judge Taylor wasn't his first victim, she was simply the first one with the power to fight back. The investigation into Officer Marcus Wright did not begin as a hunt for a serial predator. It began as a damage control operation. The police department, desperate to insulate itself from the liability of arresting a federal judge, opened Wright's case files expecting to find sloppy paperwork or minor procedural errors. What they found instead was a roadmap of systemic racial targeting that had gone unchecked for 3 years. When federal investigators in internal affairs began cross-referencing Wright's arrest logs with demographic data, a statistical anomaly emerged that was impossible to attribute to chance. In the same patrol districts, working the same shifts as his colleagues, Wright arrested black drivers at a rate 5 times higher than white drivers. But the data revealed a more specific, disturbing variable. Wright was not targeting gang members or violent criminals. He was hunting success. His arrest reports showed a fixation on luxury vehicles driven by black professionals. Doctors, lawyers, business owners, individuals with the social capital to challenge him, were stopped for vague infractions like failure to maintain lane or suspicious behavior. The pattern was surgical. Wright would initiate a stop, escalate the tension, and then arrest the driver on charges of disorderly conduct or resisting arrest when they questioned his authority. In almost every instance, the charges were later dropped due to lack of evidence. But the humiliation, the fingerprinting, the mugshots, the holding cells had already been inflicted. Investigators uncovered the motive in the locker room. Witness statements from fellow officers revealed that Wright had bragged about putting uppity people in their place. He kept a mental and sometimes physical scorecard of the suits he had humiliated. This wasn't just bias, it was class warfare waged under the color of law. The investigation found that 19 citizen complaints had been filed against Wright in 36 months. Every single one had been dismissed by his supervisors without a formal inquiry. While the department scrambled to contain the fallout, Judge Taylor went on the offensive. She retained Angelique Martinez, a civil rights litigator known for dismantling corrupt municipal agencies. Martinez didn't just file a personal injury claim, she filed a federal lawsuit under 42 U.S. Code, Section 1983, alleging that the city, the chief of police, and Wright had conspired to violate the civil rights of citizens through a pattern and practice of discrimination. The lawsuit triggered the discovery phase, granting Martinez access to internal department communications. This is where the defense collapsed. Martinez uncovered emails between Wright and his direct supervisor, Sergeant David Walsh. One email read, "Wright knows how to handle the troublemakers. Sometimes you have to show these people who's in charge." Another explicitly discussed reassigning Wright to neighborhoods with higher black populations to boost arrest statistics. The rogue cop narrative evaporated. Wright was not an outlier. He was a weapon the department had sharpened and deployed. As news of the lawsuit broke, the silence from Wright's previous victims ended. Martinez's office was flooded with calls. She identified 43 individuals who fit the pattern. Dr. Michael Stevens, a trauma surgeon, gave a sworn deposition detailing how Wright had stopped him en route to emergency surgery. Despite Stevens identifying himself and the urgency of his travel, Wright forced him to stand in the rain for an hour while he dismantled the interior of his BMW looking for drugs that didn't exist. Stevens missed the surgery. Sarah Johnson, a corporate attorney, testified that Wright arrested her in front of her children because she asked to see the radar reading after a speeding stop. She spent 6 hours in a cell before being released without charges. David Chen, a restaurant owner, was handcuffed outside his own business because Wright decided he looked suspicious, unlocking the front door. These were not police errors. They were acts of dominance. Wright's legal defense team attempted to build a shield around the concept of qualified immunity, a legal doctrine that protects government officials from liability unless they violate clearly established statutory or constitutional rights. His attorney argued that Wright had made a good faith mistake regarding Judge Taylor's identity. They claimed he genuinely believed the federal ID was a forgery. Martinez dismantled this defense before it even reached a courtroom. She presented the access logs from Wright's patrol car computer. The logs proved that Wright had accessed the federal database, which verified Judge Taylor's identity before he arrested her. He had seen the truth on his screen and chosen to ignore it. There was no good faith. There was only malice. The city's legal team, realizing they were defending the indefensible, tried to settle. They offered significant sums to make the case disappear. But Judge Taylor wasn't looking for a payout. She was looking for a precedent. She rejected the offers and demanded a jury trial. She wanted the evidence, the audio, the emails, the scorecard, entered into the public record. The collapse of Wright's career was total. His badge was pulled, his pay was suspended. But the true danger was no longer just professional. The FBI had completed its preliminary review and was moving toward a grand jury indictment. Wright was no longer just a defendant in a civil suit. He was the target of a federal criminal probe that carried a potential sentence of decades in prison. As the trial date approached, the courthouse became a focal point for national media. The narrative had shifted from a traffic stop to an indictment of American policing. Wright, now isolated and abandoned by the blue wall that had once protected him, walked into the courtroom not as an officer of the law, but as a symbol of its corruption. The jury was seated, the evidence was locked, and the legal consequence was about to begin. The trial of Taylor versus City of Metro opened 6 months after the incident, not in a quiet hearing room, but under the glare of national scrutiny. The courtroom was packed, the gallery divided between civil rights activists and the law enforcement fraternity. But as the proceedings began, it became clear this would not be a standard liability case. It was a public autopsy of a police department. Judge Barbara Taylor took the stand first. Her testimony was devoid of the tearful theatrics often seen in civil plaintiffs. Instead, she delivered a masterclass in constitutional law. Under direct examination by Angelique Martinez, Taylor did not simply recount the events. She legally categorized them. She described the initial stop not just as an annoyance, but as a violation of the Fourth Amendment's protection against unreasonable seizure. She framed the search of her purse not as an invasion of privacy, but as a breach of probable cause standards established by the Supreme Court. The jury wasn't listening to a victim. They were listening to a federal judge indict a police officer from the witness stand. Then came the defense. Wright's legal strategy relied on the narrative of the split-second decision, arguing that police work is chaotic and officers must be granted leeway. This defense evaporated the moment Wright took the stand. Under Martinez's cross-examination, Wright's arrogance resurfaced. When asked to justify the stop, he offered contradictory explanations, first claiming erratic driving, then shifting to suspicious behavior. He could not articulate a single specific traffic violation that withstood scrutiny against the dash cam footage. But the turning point, the moment the case shifted from negligence to malice, arrived when Martinez introduced Exhibit 44. It was body cam audio from a previous arrest Wright had made of a black university professor. The courtroom went silent as Wright's voice echoed through the speakers. "These people think their fancy degrees make them better than us. I'll show them who really has the power." Wright's face drained of color. The audio stripped away any pretense of good faith errors. It revealed a calculated motive. Wright was not enforcing the law. He was enforcing a racial and social hierarchy. Desperate to limit financial liability, the city's legal team attempted to pivot. They argued that Wright was a rogue actor, operating outside of department policy and training. They claimed the city could not be held responsible for the independent actions of one bad apple. Martinez was ready for this. She presented the internal affairs records, 19 citizen complaints filed against Wright in 3 years, all dismissed. She showed the jury the email from Sergeant Walsh praising Wright's aggressive tactics in minority neighborhoods. Martinez argued that the city hadn't just failed to stop Wright, they had incentivized him. By ignoring the complaints and rewarding the high arrest numbers, the department had ratified his conduct. In legal terms, this established Monell liability, proving that the constitutional violation was the result of an official policy or custom. Dr. Angela Foster, an expert on police bias, testified that Wright's behavior was a textbook example of authority maintenance, where officers use the badge to dismantle the social status of minorities they perceive as threats. A former police chief testified that Wright's actions violated every standard of modern policing, calling it the most egregious conduct he had reviewed in 30 years. Closing arguments were stark. Martinez did not ask for sympathy. She asked for deterrence. She told the jury that a verdict for Wright was a verdict for a police state where the Constitution is optional. The jury deliberated for only 4 hours. The verdict was a landslide. The jury found Officer Marcus Wright liable for violating Judge Taylor's civil rights. They found Sergeant Walsh liable for supervisory failure. They found the police chief and the city liable for maintaining a culture of discrimination. Then came the damages. The numbers were designed to send a shockwave through the municipal government. The jury awarded Judge Taylor $2 million in compensatory damages for the violation of her rights and the emotional distress. But it was the punitive damages that made history. $4 million assessed against the defendants to punish the conduct and deter future violations. A total of $6 million. When the foreperson read the numbers, the courtroom erupted. Judge Taylor remained impassive, a picture of judicial stoicism. Wright stared at the table, realizing his life was effectively over. The civil verdict destroyed his finances and his reputation. The city would be forced into a federal consent decree, stripping the department of its autonomy. But as the courtroom cleared, a different group of men in suits remained near the back. They weren't journalists and they weren't civil lawyers. They were federal prosecutors from the Department of Justice. The civil trial had proven Wright was a liability. Now, the FBI was ready to prove he was a criminal. The check had been written, but the handcuffs were just coming out. The $6 million civil verdict was not the end of Marcus Wright's reckoning. It was merely the administrative precursor to his destruction. While the city of Metro scrambled to cut checks and salvage its credit rating, the Department of Justice was finalizing an indictment that would shift the venue from a civil courtroom to a federal penitentiary. 6 weeks after the civil jury walked out, federal prosecutors unsealed the charges. Wright was not just facing professional disgrace. He was facing deprivation of rights under color of law, false imprisonment, and conspiracy. But the indictment went further. It named Sergeant David Walsh and Police Chief Robert Martinez as co-defendants. The federal government was not just prosecuting an officer, it was dismantling a command structure. The criminal trial ripped the last shreds of cover from the department. Prosecutors introduced evidence that escalated the narrative from racial bias to organized crime. Witnesses testified that Wright had planted narcotics on suspects to manufacture probable cause. A confidential informant, granted immunity, detailed how Wright sold operational intel to local drug networks, tipping off dealers about raids in exchange for cash. The law and order defense collapsed under the weight of racketeering realities. The blue wall of silence, often impenetrable in police misconduct cases, disintegrated. Officers who had previously looked the other way took the stand to save themselves, describing a culture where Walsh encouraged aggressive profiling to juice statistics and Martinez buried internal affairs reports to protect the department's image. Wright sat at the defense table, watching his former colleagues auction off his freedom to secure their own. Sentencing day arrived 18 months after the traffic stop. The outcome was historic. Police Chief Martinez, the architect of the department's corruption, was sentenced to 12 years in federal prison for maintaining a criminal conspiracy. Sergeant Walsh received 8 years for his role as the enforcer of discriminatory policy. Then, Judge Robert Chen turned to Marcus Wright. He characterized Wright's conduct as a cancer on the institution of law enforcement. The sentence was absolute: 15 years in federal prison, followed by 3 years of supervised release. Wright, who had spent his career inflicting confinement on others, collapsed into his chair as the reality of his own incarceration took hold. He would be 62 years old before he walked free. The fallout was total. Wright's pension was forfeited. His wife filed for divorce and moved the children across the country to escape the stigma of his surname. His home went into foreclosure. The badge that had been his shield was permanently revoked, and he was banned for life from law enforcement employment. But the consequences extended far beyond the 3 defendants. The entire police department was placed under a federal consent decree, stripping it of operational autonomy for a decade. Every hire, every policy, and every disciplinary action would now require federal approval. The city was forced to reopen cases involving Wright, leading to an additional $42 million in settlements to doctors, teachers, and business owners who had been silent victims of his predation. Judge Barbara Taylor returned to the federal bench, her authority compounded by her survival. She didn't just go back to work, she went to Congress, testifying on the necessity of independent oversight for police misconduct. The intersection where she was stopped became a quiet landmark in legal circles, a physical coordinate where the rule of law collided with the abuse of power and won. Yet, as we close this file, we are left with an unsettling variable. The cognitive itch that remains is not about justice served, but about the statistical improbability of it all. Marcus Wright's downfall didn't happen because the system worked. It happened because he made a targeting error. He pulled over the one woman in the city who had the legal knowledge to preserve the evidence and the judicial standing to be believed. If Barbara Taylor had been a nurse, a mechanic, or a retail manager, her protests would likely have been buried in a filing cabinet, just like the 43 victims before her. Wright would still be on patrol. The corruption would still be active. Justice in this case was not a systemic feature. It was a lucky break. This case exposed the fragility of a system that relies on the status of the victim rather than the integrity of the officer. But while the dismantling of the Metro Police Department was absolute, the patterns of corruption are rarely isolated to one precinct. If you think this abuse of power is shocking, the case on the right-hand side of your screen involves a conspiracy that makes Wright's operation look like amateur hour. Click there now.